I learned a lot of what I know about taking depositions from a gentleman named Robert Musante. Mr. Musante is well known. If you Google his name, he has some pretty good courses online about how to take depositions. You can go through them. He kind of dissects the depositions of some pretty high-profile individuals, which is very interesting. In my series here, we're going to be talking a little bit about Bill Clinton and testimony that he gave in certain cases. And it is very interesting looking at it from the perspective of an accomplished attorney who takes a lot of depositions and knows kind of what you're looking for in that. So the first thing that I want to start with in this section, deposition is trial, is Musante's quote, "Mediocre adverse depositions abound, while high quality ones are a rarity." And that is exactly what I have found. I have found that a lot of attorneys go into depositions, they don't really know what their goal is, they don't really know what they're doing, so they just start asking questions like they've seen other people ask questions, but they don't really have a purpose, they don't have a goal. And those attorneys just kind of meander around and they're asking all kinds of questions about all kinds of things, but most of it's useless. Most of it will never be used outside that room, the deposition room, and certainly won't be used at trial. So they're missing the whole point of a deposition, and that is the definition of a mediocre adverse deposition, where you're not really getting any testimony you can use for trial. The key to a good deposition is knowing that when you walk into that deposition room, you are walking into a trial. The trial has already begun. And I've had that conversation with many attorneys on the other side trying to argue with me over certain legal principles regarding the deposition, and my response is, look, this is trial, this is cross-examination, so I'm allowed to do certain things. So my first part of this video series is the statement, deposition is trial. So in CCP 2025.620C, it says, an adverse party may use for any purpose a deposition of a party to the action. And the deposition of witnesses section is CCP 2025.620A, which says any party may use a deposition for the purpose of contradicting or impeaching the testimony of the deponent as a witness. So when you prepare for trial, as a trial attorney, at least the way I do it, a huge part of the trial itself, and especially cross-examination, is you rereading portions of the deposition of the opposing party and the deposition of opposing witnesses. That is a huge part of trial. And the cross-examination of these adverse witnesses and the cross-examination of the other parties are mostly based on the deposition testimony that you've received from those adverse parties and adverse witnesses. In fact, my trial cross-examination process is basically reading through the deposition and picking out certain nuggets of testimony nuggets, adverse testimony nuggets from the deposition transcript, and then you read them verbatim back to the witness at trial in the form of a question. That's what cross-examination, a large part of it is. Isn't it true that A, B, and C happened? Isn't it true that the light was red? Isn't it true that you met with this person and talked with them on a particular day? You already know the answer to that question because they've already testified in their deposition as to what the answer is. So you know the answer already. All you're doing is reading back the question to the witness in the form of a leading question that says, isn't it true that? And then you read their deposition testimony to them. If at any point in the cross-examination they say anything to you except, yes, that is true, now you impeach them. How do you impeach them? You impeach them by reading their exact quote from their deposition. You tell the judge the exact line and the exact page of the text that you just questioned the witness about. And I'm going to give you an example. So an example is, at the deposition, you ask the witness, what color was the light? And they say the light was red. So, okay. So when you get to trial, you ask it in a little bit different way. You say, the light was red, right? And then let's say at trial, the witness says, no, the light was green. Okay, well, now you got him. Why? Because you have the exact question at the deposition where the witness said the light was red. So this is how it would go. I'm the attorney. The light was red, right? And the witness says, no, the light was green. And at that point, you stop and you turn to the judge and say, I'd like to read from the witness's deposition testimony, page 4, lines 5 through 7. And you pause. And you wait for the judge to pull it up, because you've given the judge a copy of the transcript beforehand. You allow the other side to read the question and the answer. And as soon as everyone's okay with you reading it, then you go ahead and you read it. And what I would do is read from the deposition transcript. What color was the light? Answer, red. And then you move on. That's all. You've basically established that the witness at the deposition gave the answer red. And you don't have to say, why did you change your answer? Or, hey, you changed your answer. Or say, why does your deposition say something different? You don't have to do any of that. You just read from their deposition. And the authority for doing that is back to CCP 2025.620, which says an adverse party may use for any purpose the deposition of a party to the action. So that's how you impeach a witness at trial. Now, at trial, after you do this to them and you've impeached the witness, on rehabilitation, their attorney might try to explain the change in the testimony, but you will just have to deal with that at the time. But the point is, you've made the point to the judge that this witness changed their testimony and is either lying or they are not credible or they are not dependable. And that's how you impeach a witness. And the judge is usually going to stick with the deposition testimony. That's why the deposition testimony is so important. You've locked that in at deposition, and so by the time you get to trial, they can't change it. And you're going to ask them leading questions to elicit that certain testimony. All right. If you go through a particular questioning on a topic in a deposition, you have to always remember why you are doing it. The answer is, I'm doing this question at a deposition to have testimony for trial. That's why I'm doing this. So your question in the deposition has to be clear and the answer has to be clear. In the deposition, you need a clear question and a clear answer to read to the judge at the trial. So that's your destination here, clear trial testimony. That's why, again, deposition is trial. So at a deposition, you may need to rephrase the question several times so you can get a clear answer. And you can keep going. The purpose of a deposition kind of is to do dry runs of these questions, and you can ask them over and over again until you get a clear answer to a clear question. Then when you get to trial, you can take all the preamble to that, all of the conversation that led up to the clear question and the clear answer, and you don't have to read that at trial. You just stick with the final clear answer to the clear question. So I'll give you an example of that. So here's the example. You're at a deposition and you ask the witness, what color was the light when you arrived at the intersection? And they say, well, as I came up to the light, there was this guy driving a yellow car next to me, and I started looking at him. Well, that doesn't answer your question. So then you follow up in the deposition. You say, well, right, but my question was, what color was the light? And then maybe the attorney says, objection, lack of foundation, misstates the testimony. And then the witness might say, well, I was talking about the yellow car, but the light had changed. So I don't know if it was a yellow car, the red car that came through the light. Again, very confusing, right? Witnesses do that all the time. They're very confusing. So then you say, look, did you look at the light when you came to the intersection? And then the witness, yes, I was able to see it. Question, so when you looked at the light as you approached the intersection, what color was it? Answer, it was mostly red, but it was changing. Question, right, but when you arrived at the intersection, did you see the color of the light as you arrived? Answer, at a certain point, I noticed it was red. Question, right, but when did you first notice it was red? Answer, before I got to the intersection. So this whole question and answer leading up to this is pretty jumbled, right? It's pretty confusing. So that's why at the end of all this, you have to re-ask the original question now with having gone through this with the witness, and then the question will be, so the light was red when you arrived at the intersection, correct? And the witness says yes. that last question and answer, that's what you're going to use at trial. Not the rest of the stuff, just that part. So the light was red when you arrived at the intersection, correct? Answer, yes. Now you go to trial and you say, the light was red when you arrived at the intersection, correct? And if the witness says no, you're just going to read from their deposition. You got them because you took the time to go through all this stuff about the objections and the distractions about the other cars that were around, and you focused on the question that you wanted answered: what color was the light when you entered the intersection? The purpose of this line of questioning, as you can see, is to get to a destination. And you always have to know that when you're taking a deposition, you're asking a certain line of questions, you're trying to get to a destination. What is the destination? The destination is to get that nugget of testimony that you can use at a trial when you're cross-examining a witness. And then that's going to form the basis for the argument of your case and ultimately your closing argument, and you're going to have that on the record for appeal. Now, once you lock in that question and answer, and once you get at trial once you get at deposition your testimony nugget, then you move on. Don't keep asking questions about that. Once you get them to say, so the light was red when you arrived at the intersection, correct? And they say yes, you're gone. You're on to the next topic, because witnesses will try to muck up the record. The attorneys will try to muck up the record so that when you get to trial, you can't use the testimony. But you want a clear question, a clear answer, and then you move on. So you get your testimony nugget, the part that you're going to read at trial, and then you're off of it. You're going to move on. The purpose of a deposition, in general, in the end, is to get as many nuggets of testimony as possible. What I tell witnesses when I'm preparing them for a deposition is, look, when I take a deposition, what I do is I ask all these questions. And then afterwards, I read the transcript and I have my highlighter pen and I highlight the sections of the deposition where I have a clear question and a clear answer that's adverse to the person that I'm deposing, across the opposing party. That's my cross-examination. And I take that little nugget, I stick it on a piece of paper. And then I keep reading through and I find another nugget and I take that and I cut and I paste it and I put it on the same paper. And I do that for the whole deposition. And by the end of the deposition might be 200 pages long. But what I've done is I've accumulated 30 to 40 testimony nuggets where clear questions, clear answers that relate to our case. And guess what my cross-examination is? Me reading those 30 to 40 testimony nuggets that I have in front of the judge, getting the testimony I need, and that's cross-examination. Now, other things are going to come up. You're going to need to improvise a little bit, but in the end, that's pretty much what my cross-examination is. And guess where it all stems from? The deposition. So if I take a good deposition, I'm going to end up with a bunch of great sound bites or testimony nuggets of adverse testimony to the person who's testifying, get him to admit things, get him to say things, and now we lock those in. And then at trial, the cross-examination is just simply reading all of those to the witness, getting him to say yes. And again, you're always asking leading questions. You're always asking questions where you already know the answer. If they stray from the answer, you just read from their deposition and you move on to the next one. When I was at the NIDA, which is the National Institute of Trial Advocacy, I was at a boot camp, and they had this cartoon. And it was a great cartoon, which I'm going to try to find, but it had a cartoon of an attorney that was up at a stand in court questioning the adverse witness. And basically, the cartoon showed the attorney with one foot asking the question, and then the other foot, the long leg reaching around behind the witness stand. And now the attorney was almost asking the attorney himself the question, because the attorney who was asking the question already knew the answer, and the answer should always be yes. So the attorney was basically asking a question that the attorney was answering at the same time, and it should always be yes. There should never be a witness asked a question in trial that is a who, what, why, how, or when question. You should never ask those at trial of an adverse witness. Your questions need to be leading questions. The answer of the witness should always be yes or no, whatever you decide based upon their deposition testimony they've already testified to. If they stray from that, you read from their deposition testimony, and that's why at the deposition you are already in trial. You use that to cross-examine at trial, and you're halfway through having a successful trial. So that's the end of part one. Deposition is trial. And next time we're going to be talking about locking in witness testimonies and asking closing questions.